signed into law by the president, passed by the National Assembly, of course, and signed by the president, and all of the issues that have come up, where that is concerned. And he is somebody that's, I mean, he's here already, came in very early, which is very much appreciated. But he is somebody who has been in the CAC for a while, so it's not like he's new, to this. This particular act, interesting enough, has not been touched for 30 years, well, close to 30 years before it finally got, reviewed, amended, and then, signed again. And it has been commended in different quarters by the business community. You have had several, business communities saying that this is what is needed right now because of the way it would ease, burdens for SMEs, which is what Nigeria really needs. But then there's a part of it that is gaining a lot of traction with CSOs and religious bodies, all agitating over that. So we thought it, right to bring him in to help us make sense of it. So welcome to the show, sir.
Thank you. Good afternoon.
Okay. Great to have you here. I already, of course, introduced what we're talking about, which is the Companies and Allied Matters Act 2020. I want us to start off with, what it's going to do for SMEs, because I remembered when it was first signed and I had my business show, a lot of the analysts were talking about how this is fantastic. This is great for businesses in Nigeria. So I want us to start off from that and talk about, what it does for Nigerian businesses.
Okay, thank you. I will start with even the company formation process. Under the new law, one person can register his company. Unlike what we had under the 1990 Act, where the law says you must have minimum of 2 persons. So as an entrepreneur, you are not obliged to bring another person into your business. And in the course of implementation of the old law, we've seen what has happened, particularly where strange bedfellows were made to operate a business together. And in most cases, you'll discover that the second person may not even have any significant interest. He was just brought in because the law says you must have 2 persons. And when there are issues, because you can't take decisions alone, you must need the second person, it was always a problem. So with this new provision that a single member can register and operate his company, you can also have a single director, where that company is a small company. But if it is a company other than a small company, then you must have 2 directors, but you can still have single shareholder. The law has also provided some new things to ease the burden of these new companies. One, you don't need a lawyer in the registration process. Unlike before, where the law requires that you must have a legal practitioner involved, he has to post a declaration that the requirements of the law has been complied with. Our concern as a regulatory agency has been that most often the cost of professional services was even higher than the cost of registration. So in situations where a small entrepreneur that may not even have the capital to invest, he may not even have the money to pay for the registration fee, maybe he had to borrow the money, then you are insisting that he must go through a professional to register. That was quite burdensome. Though we are glad that the new law has made it optional. So if you are the applicant, if you are the first director or the shareholder, you can approach CAC directly and register your company without involving a lawyer in the process. Other things that have been relaxed, the strict requirement to have a common seal is optional. Then for small companies, the law says you mustn't have a secretary. Unlike before, where every company must have a secretary. The practice then was lawyers engaged in the process will make themselves secretary. And the company has to pay them in some way for rendering these services. Now the company has the option, a small company has the option not to have a secretary. Also the issue of audited accounts. That is optional. Sorry, a small company does not have to audit its account. All you are required to do is to maintain the income and expenditure account. When you are filing returns with CAC, you just indicate your turnover and net asset for a particular year. And that will suffice. So, the cost of all this governance, the issue of appointment of auditor, appointment of secretary, it comes with a cost. So we are glad that this has now been eased for small companies. They can operate their business, provided they maintain their financial records. But what is a small company that qualifies for all these exceptions? Under the 2020 Act, the law says a small company is a company that has a turnover of not more than 120 million or net asset of not more than 60 million. And that company shouldn't have foreign participation or any government participation. And the directors of the company amongst themselves must own at least 51% of the shares. But there is a provision there that says the turnover and net asset may be varied by the CAC. So we've looked at the 120 million and the 60 million. This is quite significant. We are likely to come out with regulations that will harmonize the provisions of our law with what obtains in the Finance Act. The Finance Act provides for a turnover of 25 million for exemptions from taxation for small companies. So our regulation will likely maintain the same threshold as in the Finance Act. This will help so many companies, and it will bring, because ordinarily a turnover of 120 million is significant. How many companies actually achieve a turnover of 120 million in a year? If you do that, most private companies will escape the net of this disclosure. So we'll lower the turnover. There are so many other things that are beneficial to small and private companies in the new law.
Yeah, let me talk about it because this caught my attention. Two particular ones, provision of electronic filing as well as business rescue provisions for insolvent companies. Let's talk about those two because
Okay.
I think that they're quite significant.
Okay, thank you. Electronic filing had actually started even before the law took effect.
Okay.
CSE introduced first deployed the use of electronic workflows in 2004. But until 2017, when the company registration portal was deployed, customer didn't have the interface to deal with CAC end-to-end electronically. Since 2017, you can register your company, upload your documents, sign these documents. The only requirement then was that after the incorporation process, after you have submitted all the documents electronically, you must submit the originals to CAC before the certificate of registration can be issued to you. We have dispensed with that. So once you scan and upload your documents, that will suffice. Moving forward, we intend to create an end-to-end electronic solution where every company will have its own username and password, so that any filing coming through that medium is deemed to have come from the company. And we can go ahead and change this and accept the changes or any filing from the company. So that, we believe, will ease a lot of burden for these companies. They may decide to create other people. They may give it to their secretary. It may be the managing director. It could be anybody. Provided filing comes through that medium, is deemed to have come from the company. This is what obtains globally. In the UK today, when you register a company, after the registration, they will send you a username to your postcode. In Nigeria, we don't have a good postcode system. So it may require physical presence of one of the directors or one of the officers to collect this password and username. Or if there is an email address that was used during the registration process, we may send this username and password to the user address. Then with that, you'll be able to log in and file any changes. And that will suffice for the purpose of signature. Then if you may want to upload your signature electronically, you should be able to do that. So this is what we are looking at for electronic signatures. Then the second question.
Second one, the business rescue provisions. For
Yes, business rescue, yes. You know, until the 2020 Act, if a company borrows money from a bank or any lender, that company was usually at the mercy of this bank. The company does not have any option to come out with any arrangement based on its own terms and conditions. And from our record, companies that had undergone receivership, they hardly come out of this receivership. And what are we talking about? In a company, the stakeholders are not just the lenders. You have employees, you have the community where this company is situated, you even have the government that collect taxes from these companies. So if you allow the company to die, all the stakeholders will lose. So the focus of the business rescue provision is that the company can come out with a proposal, and that proposal will be filed with the court, for the court to appoint an administrator that will manage the company to pay the debt. At least in doing that, you will secure jobs, and even government will collect its taxes, and the community. The whole essence is to see how the company will survive, to continue in operation. Because if you allow the lender to step in, the lender is only interested in recovering his money, and as quickly as possible. So it may be detrimental, not just to the government, but to also employees. And we are talking of preserving jobs. So this new arrangement will be done under the supervision of the court. And the law has also provided for licensing of business rescue practitioners. There's a provision that people say is controversial, because the law says members of the Business Rescue Association of Nigeria. And there's nothing wrong with that. The argument was that this is an association, it's a private association. But if you look at all other chartered associations like ICANN, like even the Bar Association, like ICSAN, they started as private. Bar Association is still a private organization registered by CAC, but they are members of our board. The law recognizes them as members of the board. As we speak, there is no association or organization in Nigeria that conducts training on business rescue other than BRIPON. So there's nothing wrong in that. And the law has also provided that CAC may accredit other professionals outside the members of BRIPON. So, but in doing that, we won't just accredit lawyers and accountants or anybody. We have to ensure that for anybody to be accredited, he had the necessary skills to engage in business rescue. Business rescue is not receivership. Business rescue is not liquidation. So if you are acting as a liquidator, that does not qualify you to engage in the business of business rescue. So CAC will ensure that people to be appointed are eminently qualified to engage in that line of activity.
Let's talk about BRIPON for a minute. You know, I mean, what is the requirement for people to be members? Because there was that conversation going on that it's just people that you choose, you know, that are there, and that it wasn't done in a transparent process. So who can be a member of BRIPON?
No, it's not true. You have to undergo some form of training. You write a certification exam. I don't know the details, but this is the requirement. And it's similar to every other professional body. As of today, you can't just walk into ICANN or ANAN and become a member of ANAN.
You have to write a certification exam.
You have to undergo that process. You have to write exams. You have to pass the exam before you are qualified. So, you see, it's normal for people to say anything. But we won't just accredit anybody. And I think it's a step forward. Bro, that will give BRIPON the opportunity to now pursue its charter status, similar to what other agencies have done.
But let me ask you this
Yes.
still, because I want to be very clear on the business rescue provision. So when this person comes in, most likely from BRIPON, at the end of the day, as an administrator, you know, to make sure that the company, you know, is run properly, does that mean that the person who collected the loan is set aside?
No, not at all.
You know, and then who pays this administrator? He's paid from the business as well?
Of course, you have to pay him for his services, because but the fundamental issue there is he's accountable to the court. It's similar to where an official receiver is appointed by the court for the purpose of liquidating a company. The official receiver is accountable to the court. Or where you have winding up by the court. When a court appoints a liquidator, that liquidator is accountable to the court. So the court will give him his terms of reference, and for every step that he took, he has to render returns to the court at defined interval. And what the law says is, immediately the arrangement is consummated, the powers of the director ceases. So the administrator will step in, he will manage the affairs of the company with the sole objective of paying the creditors. But he will do
the company afloat.
Yes.
Is there certified?
Yes, keeping the company afloat and paying the creditors. But he will do it in a manner that will not kill the company. But you see,
is there a time frame?
No, it depends. The court will determine the time frame.
Okay.
It depends on the intricacies of the issues. It depends on the extent of liability. And it depends on whether because before the court even intervenes, the company has to find out. The court has to find out whether the company has even the resources to pay off these debts. Whether there are enough resources that can be managed to salvage the company. If it is a hopeless case, I don't think the court will intervene to appoint an administrator.
So it depends on, you know, when the books of the company is checked and you're like, okay, yeah, you do have a potential to pay. You just need proper management and all of that.
Yes, because the process has to be initiated by the company itself. The company will go to the court with a scheme, telling the court that we have this, we have that, we have that. In our view, we can pay back this debt, but we don't want to do it. As directors, we want to step aside. We want the court to appoint an administrator, because there might have been trust issues between the directors and even the lender. And if they allow the lender to come in, the fear is they may kill, that company may die. So they may be interested in continuing with the business. And the company sometimes may have enough resources. Because when a creditor steps in, you have what you call market value and force value. For a creditor that is interested in realizing his money, if he can get if there is a property that he can sell at open market value and there is no buyer, he will sell at first sale, because his primary interest is to recover his own loan. So, but the issue, the concern is not just about the creditor. In as much as a creditor should recover his own exposure from the company, it should be done in a manner that at least will not kill this company.
Absolutely. Okay, so that has been cleared up, because I definitely wanted to make sure that I understood that properly and that people can actually be able to follow that. Now let's go on to the very, very controversial part of this, and that is Section 839, that has, gotten a lot of people talking. It has drawn, criticism from CSOs, from religious bodies. So let's talk about that. According to this in Section 839, because I want you to break it down for me, but I'm going to tell you what is circulating in the report. It empowers the commission, to suspend trustees of an association and appoint interim managers to manage the affairs of the association where it reasonably believes that there has been a misconduct or mismanagement in the administration of the association. Okay, so that is part of it. Of course, there's a section 2 that follows. So the trustees shall be suspended by an order of court upon the petition of the commission or members consisting of 1/5 of the association, and the petitioners shall present all reasonable evidence or such evidence as requested by the court in respect of the petition. So let's talk about this particular provision. Why do you think that it is drawing such, I want to hear from you why you think it's drawing such criticism before I get to asking you questions about it.
One of the reasons why it's drawing criticism, people have conducted their affairs in a manner they didn't fit, without any close scrutiny. So now that the law says there should be proper scrutiny as to how these funds, as to how these associations are run, and how these funds are managed, of course we should expect a resistance. Because the legal framework for incorporated trustees was based on the provisions of the Land Perpetual Succession Act 1948. When that aspect was being moved to Kama in 1990, there was no any amendment. So you can imagine a 1948 law still applicable in 2020. What we try to do is to look at the best practice globally. I must admit, the drafting of those sections were inelegant. There was a lot of incongruity, but a law is a law. And the provisions of 839 subsection 1 is clear that CSE can suspend a trustee on grounds of misconduct or mismanagement, or where it becomes necessary or desirable for the purpose of protecting the property of the association or ensuring proper application of the property, or on grounds of fraud, or in the public interest. And if you look at section 839 subsection 7a, it says an inquiry has to be carried out. So CSE will not just wake up and remove you as a trustee without an inquiry. You are entitled to be heard. And let's also look at section 851 of the same law that establishes Administrative Proceedings Committee. So any inquiry has to be done under the auspices of the Administrative Proceedings Committee. And the person accused is entitled to be heard. He's entitled to legal representation. And even after the committee has come up with the decision, the board of the commission has to approve. And after the board has approved, because the law says the powers of CAC is subject to the approval of the minister on that subsection. So even after the board has approved, the recommendation has to be referred to the minister, and the minister has to approve. The scenario under subsection 2 relates to where the court shall suspend. And our own understanding is outside what is provided in subsection 1. If for any reason outside what is clearly provided in subsection 1, CSE feel that a trustee should be suspended, then CSE must have recourse to the court. One fundamental issue we need to bear in mind is, ordinarily, CSE doesn't even have to suspend if the members of the association are exercising their powers in accordance with their constitution. Because the constitution of every organization registered under Part C, or what do you call Part F now, provides for the manner in which trustees are appointed and the manner they are removed. And it is the responsibility of the general members of the association to appoint or remove. But in most cases, there is no difference between the trustees and the members.
Let me ask you this,
yes.
Because part of what has been going on is that it gives you a lot of powers over, these organizations. So you, as the Registrar General, of the CAC, could just suspend a board, and it gives you a lot of powers.
That is not true. That is a complete falsehood. Section 839 subsection 1 says the commission. The registrar general is not the commission. The commission is the board. And I have mentioned the provision that says even where the board approves the recommendation of the Administrative Procedures Committee, the minister still has to sanction it. And who are the members of the board of the commission? You have a chairman who is appointed by the president. You have representative of the Nigerian Bar Association. You have representative of the Institute of Chartered Secretaries and Administrators of Nigeria. You have representative of Manufacturers Association of Nigeria. You have representative of NASIMA. You have representative of the Federal Ministry of Justice, Federal Ministry of Trade, Federal Ministry of Finance, Securities and Exchange Commission. There are 12 members, Nigerian Association of Small and Medium Enterprises. So all these are the members of the commission. The Registrar General is just one member out of 12. So this power is not absolute and is not vested in the Registrar General. The power is vested in the commission, which is still subject to the approval of the minister.
The minister. So let's talk about this. There's also, because I'm going to try to bring out all of the criticism that is facing. There is the idea that Kama was just putting, as a way to sneaking the NGO regulation bill in disguise, which was always talked about in the National Assembly. There was criticism against it, felt like there's a pause to it, which, tries to know about, monies that are coming and know about the affairs of an NGO. And that this is exactly what Kama is going to do, is going to know the affairs and know everything that goes on with every company.
Why should government not know about the affairs of NGOs? Why should government not know? Why shouldn't government
dictate how?
Government will not dictate how this money. No. With due respect, the major distinction between associations registered as incorporated trusts and companies is that the income and property cannot be shared by the members. If you are a trustee, you are not entitled to remuneration. You are not entitled to bonuses. You are only entitled to out-of-pocket expenses when you attend meetings or other official functions of the association. I don't see why people should fear this. The only people that will fear this is people that are misapplying the funds of this association. If you are conducting your activities in line with your constitution and in line with the law, you don't need to fear anything. But if you are the type that receives donation for one purpose and apply this money for another purpose, then you should be concerned. Because the public should know, mind you, even where you are the sole donor to the association, you cannot spend this money based on your own whims and caprices. The law is clear that any association registered, where one or more trustees are appointed by any community of persons bound together by custom, religion, or kinship, or where anybody or association established for any literary, scientific, cultural, religious, development, social, educational, such as their objectives, they may appoint 2 or more trustees. And the trustees are the legal representatives. And the law is clear on the responsibilities of these trustees. And the law also says the trustees, the governing council shall include the trustees. So except you are an employee, you are not entitled to remuneration. And why should people be concerned? Why should CSO
let me bring this down, because the idea is that at the end of the day, if you're saying that, yes, it's not you personally, it is the CAC, it's the commission itself, but then there is the huge trust issue, because you're asking why should they be concerned. That is part of the reason that they're concerned. Nigeria suffers a deficit of trust between government and the citizens, and it is well earned. That is the truth. So when you bring a law or whatever, a policy, if there is no carrying of people along, there is bound to be that idea of, are you out to get us? I'm just trying to explain why they may be concerned.
Okay, I have answered.
It is a trust issue.
No, I have answered.
How do you plan to address the trust issue?
I have an answer to that. It's like saying we shouldn't have laws in Nigeria because of trust. That's what simply people are saying. Now, with due respect, you see, as I have said, this power is not absolute, and anybody aggrieved by the decision of the commission can still appeal to the court. Because what the law says is the decisions of the Administrative Proceedings Committee, any appeal against the decision of Administrative Committee can lie at the Federal High Court. So organizations have to be regulated. And unlike companies where the law says if you are carrying on business under a name other than your full name and surnames, you must register either as a business name or as a company. For associations under Part C, you don't have to register. You have a constitutional right to associate. So if you feel you don't want government to have oversight of your activities, operate your association without registration. If your members will entrust their money on you in your personal name to carry out the activities of the association and spend this money as you deem fit, don't come to CAC.
But once you're registered, you have to be regulated.
Once you are registered, you must be subject to regulatory oversight.
But does that mean that, because I did ask you a question that you didn't respond to, that, you know, the idea of the trust, even if you feel, because you're seeing it as it is black and white. In Nigeria, there has been abuse of processes, abuse of office, abuse of policies, abuse of laws, you know, by agencies and regulatory. Let me finish, sir. At the end of the day, if people are saying, well, we see this as being targeted at this and that and that, you don't think that they have a right to feel that way, and that it is your responsibility to try to make them understand that that is not the case, as opposed to saying, this is how it is?
No, the assurance I want to give people is, we are issuing a regulation that will define what is misconduct, although the provision of the law has alluded to some of the what is misconduct and what is misappropriation. What is public interest? What is proper application of property or protection of property? And the procedure for these enquiries will all be in the regulation. But you see, it's very easy for people to dismiss laws on grounds of trust. It's very easy. This is typical of us and Nigerians. When something does not suit us, we call it all manner of names. Even the judicial process. People have questioned the judicial process. So the argument that this thing should go to court, I can assure you, even when the matter goes to court, they will still accuse the court. So, but we are public servants. We are accountable for our action. And as I have said, my powers as Registrar General is not absolute. And it's not within my authority to even suspend. It's the responsibility of the Commission. Yes.
Talking about the suspension and appointing of interim managers, there are two questions I'm going to ask you now so that you can attend to both of them. One, a very direct and maybe obvious one, you know, but you still have to answer it.
Yeah.
Is this targeted at churches? You know, just answer that. And then the second one is this: the idea of, you know, being able to appoint an interim manager. Who pays interim manager in the instance that there is an appointment? Is it the government or the association that, you know, the interim manager will be managing? That clarity is something that needs to be seen.
Okay, thank you.
So let's talk about both of them.
The provisions are not targeted at church or any individual or group. We are not doing anything different from what you have in other jurisdictions. These provisions were based on what we had under Section 76, subsection 1 of the Charities Act of the UK. Although the Charities Act has been amended in 2016, that now provides that you can suspend a trustee for failure to comply with any directive of the Charities Commission. This law, we didn't start this, the drafting was done long ago. So maybe some of the changes, because of the cumbersome process of lawmaking, we could have done some of these things differently. As I have admitted in the first instance, some of the wordings are inelegant. So, but it's not targeted at anybody or group. This is to bring our law to ensure proper accountability. Because I have mentioned this and I will repeat it again. You are a trustee. You are not an owner. And you are not entitled to any remuneration as a trustee. Your own is to ensure that whatever income is realized is applied strictly to pursue the objectives of this association. So if you are doing a selfless service, I don't see why somebody should bother.
Well, there's the idea of the separation of state and
separation of state.
And church.
State has a responsibility to regulate every organization registered, because this is public money. This money is being donated by members of the public. State should be interested in how these donations are applied, and whether individuals that were appointed by the general members are conducting themselves in a proper manner. As I have said, ordinarily, it's not even for CAC to intervene if the general membership will exercise its own powers. But how many of these organizations hold annual general meetings? How many? How many of them even maintain registered members? An organization that you may think has 1,100 members or 100,000 members You'll be surprised from the record. The trustees, based on our record, may just be the members of the association. Their own whims. This is what this law seeks to check. The law is not arbitrary. Nobody will be removed arbitrarily. You'll be hurt. It's only when you cannot provide satisfactory answer, when there are reasonable reasons to believe that there are infractions, that is when you can be suspended.
Now, let me ask you this. How do you know if there is an infraction? How do you know that if there's been a mismanagement? How does the CAC come about that information? How do you,
okay,
do you know that?
Yes. One, you can receive a petition. Where CAC receives a petition, but it's not stated there. Or two, the law requires every registered organization to file biannual statement with the CAC. The content of this biannual statement will be defined in our regulation, but it will include issues of income and expenditure of the organization. And three, the law requires every organization to maintain accounting records that will show its income and expenditure in a year. And the law also requires every such organization to submit audited financial statements to CAC at the end of its financial year. So sometimes from these financial statements, you'll be able to know whether there is a mismatch, because from the biannual statement and the final audited statement, you will see whether there is a harmony. If there is no harmony, these are matters that you can ask the trustees to explain. And if they are unable to explain, you can institute an inquiry. And if after the inquiry, you now discover that there are infractions that should warrant the suspension of the trustees, then you suspend them and appoint an interim manager to manage the affairs before you go to court to get the trustees removed. Because CAC cannot just remove without the court. CAC can suspend. But to remove, you have to go to court to remove and now replace the trustees. So this is what the law says.
Yes, I was asking, you haven't answered, who pays the interim manager?
Of course, the associate, because you have employees. Every association will have its governing council. Some of these governing council may be working on full time. Where you appoint an interim manager, the court will decide, and the court will decide his remuneration and the manner upon which this payment will be made. So, of course, the association will pay the interim manager from his own income. From its income. Yes.
I just want to ask you, are you aware of how sensitive the issue of religion is in Nigeria? You know, how we are when it comes to religion. You are very aware of that, sir.
You see, we shouldn't mix issues.
I'm just asking I know why, because I want to ask you another question.
We do respect the issue of religion. Are we talking about the differences in religion? Or are we talking about regulation of entities registered? I have told you.
I understand the regulation.
As a religious organization,
yes,
you don't have to register with CAC. But why you choose to register, you must comply with the law. You
must comply with the law. But you are aware that Nigeria is
a multi-religious, unfortunately, because we have made
multi-religious society.
Well, it is, but there are other countries that have the same multiplicity, but they don't behave like us.
But do you think that, because the reason why I'm asking that is this, do you think that it will be in good faith to hear out religious leaders and to draw up, because you're talking about setting out regulations. What it means is that is not totally done yet. Draw up some sort of guidelines to make people feel at ease about how this will be done.
I will assure you, whatever guidelines or regulations we are going to issue will be exposed. We'll invite for comments. That has been our practice since I took over in January. Even our current checklist and guidelines were exposed to our key stakeholders. We invited for their comments. So the regulations that will be issued is the minister that will issue this regulation. We are already working in-house on the regulations. It will be exposed. We'll circulate it to key stakeholders. But that is not to say that the regulation will change the law.
No, I'm not saying change the law. I'm just saying.
Yes. So because even after it is exposed, if somebody comes with a position that is contrary to the law, we are not going to accept that. We are not going to accept that. But the issue is, Gamma has already addressed this issue. Gamma has already said that anybody that wants this provision changed should approach the National Assembly.
So you're okay with the National Assembly revisiting?
They make laws. They make laws. This power is not personal to me. Yes, it's not personal.
Let me tell you one of the, because while I was addressing the sensitivity of the issue of religion is because, unless as a Nigerian, you don't want to acknowledge it. We know how volatile the issue of religion is in this country, and whatever is done, that has to always be taken into consideration because you're making the laws for the people.
But
After all, let me just finish. Where I'm going to here. This clarity that some people are seeking for is about appointing an interim manager. So there has been, something like, for example, that you might appoint somebody from another religion to be an interim manager, for an association that is of another religion. Let's talk about that. There is a fear of that.
You see, unfortunately, this is the unfortunate aspect that we trivialize every serious issue in Nigeria.
You think that's trivializing?
Yeah, that's true. Yeah,
people hold their religion very, very
You see, you need to distinguish the spiritual aspect of the religious organization from the governance aspect. The fact that you have been removed as a trustee does not stop you from your ministerial duties or spiritual duties. It doesn't stop you. Who is a trustee? I have defined a trustee.
So let me get clarification.
So what I can assure you is, and what is the role of an interim manager? The interim manager will look at the income and expenditure, ensure that it's properly managed. If there is a mosque or a church established under the law, and that church or mosque is supposed to be funding a particular activity, his responsibility is to ensure that these funds are applied strictly for that purpose and is not distributed by the members. So I cannot see, you see, why I say the trivialization. I thought we should transcend this kind of differences. By
I
now
understand
in
how you say
because
it is ideal, but it is not the reality.
You see, and as I've told you, CSE is a very responsible institution. CSE will not do anything.
So you not appoint an
no. CSE
will
not appoint anybody that will create unnecessary attention. So if you have a church, we may even appoint a clergy, another clergy, to be the administrator of an association or a church. We won't bring a stranger who has no knowledge of that calling to make him interim manager.
Good that you're clarifying.
Will not.
That was all.
No, will not. But you see, I'm surprised with the level of trivialization because you see, as a country, we just need to be serious. I can't just imagine that every issue in Nigeria is reduced to this level. All our conversations are trivial. We're not talking about how this country should move forward. We are emphasizing our differences instead of emphasizing on matters that will bring unity to this country.
The thing is this, sir. When you say things like this, it's to the average Nigerian listening, it comes across as you trivializing their feelings. Because like I said, you have to understand the dynamics of Nigeria as a multi-religious society. So when you say that people bring in religion to trivialize issues, you are actually trivializing the sentiment of the average Nigerian who holds religion close to his chest. And what it also means is that you're a little detached from what the average Nigerian is going through.
Maybe I'm more objective. Maybe I'm more.
You're saying it as black and white, but it is not.
No. Maybe I'm more objective because you see, we have to distinguish religious matters from governance matters. I have said this. And regardless of your objective, if you register an organization as incorporated trustees, the objective is secondary. What is fundamental is the governance. How do you govern this association? And I have also said it, that ordinarily, if the general membership will exercise their powers,
you would not need to step in.
Seriously, you wouldn't even need to step in. So, you see, I'm just puzzled by the level of trivialization that CSE will appoint an imam to go and be an administrator of a church. This is the height of trivialization. We will not do that. We will not do that. Or appoint a pastor
to go,
yes. And we should bear in mind that these provisions is not peculiar to one group. It applies to all organizations, whether Muslim organizations, whether Christian organizations, whether civil society organizations, whether even parent teachers association. It's the same law. But what distinguishes them is the objectives they seek to pursue and what they provide in their own constitution. So it's interesting how things are trivialized actually. But you see, as public servants, we don't see these things this way. Because first and foremost, before I think of myself as Alaji, I have to look at my office. I'm supposed to be fair to all manner of people, regardless of their faith, regardless of where they come from.
But would it be fair to also acknowledge that Nigerians have been burnt too many times for them not to
How many Nigerians? The silent Nigerians are not like this. It's a vocal few that are like this. People that have access to media institutions like your own.
And you think that
the majority of Nigerians are looking for how to live their living.
How to earn a living.
How to earn a living.
And that is probably, that's a conversation for another day, because of course it also means that they are too concerned about, them being able to eat than to look at issues policies that are being made for them. So sometimes the vocal few that you're talking about, they are their voice to address these issues that they otherwise do not have time for. I am saying even the vocal few that it sounds like you're dismissing them. They are Nigerians too, aren't they?
No, I'm not dismissing.
And they do have their
I'm not
opinions.
dismissing. You see, I only try to look at issues objectively. I didn't dismiss any opinion. As I have told you, there are process of lawmaking in Nigeria, and we didn't make this law. The Parliament made this law, and Mr. President assented to it. And this law had undergone all the due process. There was public hearing, and it was exposed to stakeholders. If people didn't send their comments, then it was unfortunate. But the bottom line is, this is the law, and the law has to be followed. But we're a responsible institution. We're not draconian. We have never been draconian. And we'll apply this law in line with our own understanding. People are still free to challenge our actions in court. The courts are there for anybody that is aggrieved.
So let me ask this as we wrap up. Can subsection 1 of section 839 be taken in isolation, or will it always be acted alongside, the other subsections like subsection 2 and all of that?
No. Subsection 1 is very clear. I have said this. But you read it in conjunction with 7A that talks about the inquiry. On the grounds of subsection 1, CAC can suspend without recourse to the court on grounds of misconduct, or mismanagement, or fraud, or public interest. The major concern has been public interest. People say that is an omnibus provision, that is too wide.
Who defines public interest?
Wait, I have said this. Our regulation will address that.
Okay.
So, but the example I want to give is, supposing you have an association that is established for a particular objective, and that association now took up arms against the government or the country. Are you going to wait till after 2 years of judicial process?
That's a very obvious.
These are the kind of scenarios we have under public interest. You have how many groups that are fighting the government, fighting the country? So, are you going to wait till eternity to take action? So all these things will be in the regulations.
Most of those ones fighting the government, they are not registered under the CAC.
Some of them may be registered. Some of them may be registered.
Well,
No,
I know most of them are not registered.
No, some of them may be registered.
What happens to
some
those
of them
that are not registered?
Well, that is even if that is the case, that's the situation today. Tomorrow you may have a different situation where a registered organization will be engaged in that. And what do? You wait for 2-3 years?
When are the regulations going to get out? These regulations that you're working on,
within the next 1 month. We hope that before the implementation, you can't start implementation without the regulations. So we have finished the in-house draft. We're going to expose it to our stakeholders, and we'll have a small committee of key stakeholders to do the final review after we have received inputs from from the various stakeholders. And it will be exposed on our website. We'll invite for comments. But as I have said, a regulation can only give impetus to the law. It can't change the law. So if anybody thinks that we are going to change any provision of the law by the regulation, we're not going to do that.
You can't do that because it's not up to you
we can do that.
Yes, absolutely. I did have somebody trying to call in. If you want to ask him a question, feel free to do so. Numbers 0817-288-7943 or 1999943, or you can send a WhatsApp message to 0909-697-5943. I got a WhatsApp message says, "Hi Faith, good afternoon. Waiting to see your guest. I'm getting a good education from your guest. He has clarified a number of gray areas for some of us young entrepreneurs." Okay, so let's take this call. Classic FM.